Welcome back to the Rule of Law the Academy Speaks with your host, Joe Tucker, and special guest, Jack Scarola. Here's part 2 of the Epstein story.
There have been Epstein victims who have named other individuals to whom they were provided by Epstein. There is information that is a matter of public record, specifically identifying some individuals to whom Epstein trafficked them.
And who does the public information, to the extent you can talk about it, indicate who these victims were trafficked to?
It's difficult for me to separate in my mind information that I have received in an attorney-client privileged context and information that's public. And because I haven't recently reviewed the public record with regard to those matters, Joe, that's probably not a question that I should attempt to answer at this time.
Got it.
The one example that obviously has received a great deal of public attention is Prince Andrew.
Got it. Let me change gears. And we talked about this sweetheart deal he got through the justice system in 2007. You actually represent, I'm going to have him on another episode, our friend and member of the Academy, Brad Edwards. Tell us a little bit about how it is that you came to represent Brad in litigation brought by Jeffrey Epstein and the result of this litigation.
As I mentioned earlier, Epstein had a large team of very experienced, capable, and skilled attorneys. And Epstein recognized the basic principle that the best defense is a good offense. He applied that principle in the litigation on behalf of victims when he was being sued civilly. He obviously took a very aggressive approach in the defense of the criminal cases, both in state court and federal court. What leverage he used to achieve the results he did, as I said, that remains unanswered. But during the course of the civil prosecutions, some of which were cases in which I was personally involved, many others were cases that were being prosecuted by Brad Edwards. And because we shared a common objective, Brad and I worked closely together in the prosecution of those claims. During the course of the pendency of those civil lawsuits, Jeffrey Epstein brought a racketeering charge against Brad Edwards. Brad, who had been working as a local prosecutor after finishing law school for a considerable period of time, then moved on into private practice. And while in private practice, he began the representation of a number of Epstein victims.
I have to stop you for a second.
Sure.
I know I understand because I've read enough about it. So Brad is representing victims against Jeffrey Epstein, and Jeffrey Epstein sues Brad.
When that lawsuit was initially brought, what occurred is that Brad was recruited to go to work by a law firm called Rothstein, something and Adler, and I'm sorry that the name is escaping me at the moment. Brad was hired by that firm, and Brad brought the then pending Epstein cases that he was already prosecuting on behalf of victims with him to that firm. Mr. Rothstein, unbeknownst to Brad, was engaged in a major Ponzi scheme. And the broad outlines of that Ponzi scheme were that Rothstein was selling interests in cases that were settled against high-profile individuals on the basis that payments would be made to victims over an extended period of time. And the purpose for stringing out the payments was to help to assure that the victims would honor the terms of non-disclosure agreements with respect to abuse that they had suffered at the hands of these high-profile individuals.
And you and I both know that's not legal.
That, however, didn't stop Mr. Rothstein. Mr. Rothstein then sold this stream of income to investors, telling them that for upfront cash that would be paid to the victims would assign the right to receive future income as part of the settlement to the investors at a very high rate of return to the investors. Rothstein managed to defraud multiple people out of vast sums of money with this scheme. And he used the real cases that Brad Edwards had against Jeffrey Epstein to help to induce investors to pay him money as part of this Ponzi scheme. Brad was entirely unaware and completely uninvolved in any misuse of his genuine files. But when the Rothstein fraud broke, Epstein seized upon those circumstances and brought a racketeering claim against Brad.
Got it.
Brad came to me to represent him in defense of those claims and to bring a malicious prosecution claim against Epstein for the claims that he had fabricated against Brad. It was in the context of that litigation, claims that Epstein initiated against Brad, that I took Jeffrey Epstein's deposition.
It's in that deposition that's often shown where you questioned Epstein about his relationship with Donald Trump. Is that correct?
Among many others, the focus of that deposition was on Jeffrey Epstein's criminal conduct, including his trafficking young girls to third parties. So it was Epstein's theory of his racketeering case that Brad had fabricated the the civil claims against Epstein, that this was all made up, that he hadn't been involved in any of this conduct, that this was a fantasy that Brad Edwards had created in order to extort settlement funds from Jeffrey Epstein and other high-profile third-party individuals. That was the basis of the racketeering claim. In spite of the fact that Epstein was the one who initiated that litigation and obviously had an obligation to provide evidence to support his claims, Epstein asserted his Fifth Amendment right with regard to virtually every question that was asked about his having engaged in criminal activity, his having abused children, his having trafficked children, the circumstances under which those events occurred, and his refusal to answer those questions.
And this was you questioning Jeffrey Epstein under oath during a deposition.
Correct.
And how many times would you estimate he asserted his Fifth Amendment right not to, against self-incrimination?
Dozens of times. Because in the context of civil litigation, the assertion of a Fifth Amendment right to remain silent, while in the context of a criminal case can't be used, in the context of a civil case is admissible evidence. And a jury is instructed that they can infer from a refusal to provide an answer to relevant and material questions in the context of a civil lawsuit, that the answers would be unfavorable if they were given. So it was to our advantage in that deposition to be asking specific questions about specific conduct that Epstein, in accusing Brad of fabricating these claims, would need to be able to prove, but which he repeatedly refused to address by asserting his Fifth Amendment rights.
Now give us the bottom line. What happened in this litigation where Jeffrey Epstein sued our friend and your client, Brad Edwards?
There were multiple parts to the resolution of the case. One very significant part to the resolution of the case that I can speak about because it is a matter of public record is Jeffrey Epstein issued a detailed public apology to Brad Edwards in which he acknowledged that Brad Edwards had done nothing wrong.
How many hours did you sit with Jeffrey Epstein during his depositions?
There's a transcript of the deposition that will accurately disclose how long that took, but my memory is it was probably about 2 hours of questioning.
During that 2 hours of questioning, and you being as experienced as you are, Jack, were you able to glean anything about Jeffrey's personality you want to share with us?
He was arrogant. He was consistently arrogant throughout all stages of my contact with him. And that contact was not limited strictly to the depositions, because he would appear in person at court hearings, and he would appear in person at the depositions of his victims, clearly for purposes of attempting to intimidate them. And his arrogance and smugness was apparent throughout every contact that I ever had with him.
Someone would suggest with a person with that type of personality, taking his life is sort of inconsistent. And I know neither you nor I are psychologists or psychiatrists, but what are your thoughts on that, Jack?
I find the idea that Jeffrey Epstein took his own life to be entirely inconsistent with not only his personality, but with the circumstances of his interaction with the law. Jeffrey Epstein was able to escape serious consequences repeatedly throughout his criminal prosecutions and throughout the civil lawsuits that he faced as well. He was at the beginning of his federal prosecution in New York. He had the resources to employ and did employ some of the best criminal defense attorneys in the country. To think that under those circumstances, he was prepared to give up the fight just doesn't make sense to me. And it's interesting that in the interview that was conducted of Ghislaine Maxwell, she was specifically asked about her opinion regarding Epstein's alleged suicide.
And for those who haven't heard it, I need you to give us that top line.
Yeah, the top line is she didn't think that Jeffrey Epstein would ever have committed suicide, and particularly not under those circumstances.
All right, speak of the devil, Ghislaine Maxwell. We've been talking about how people, and specifically rich, powerful people like Jeffrey Epstein have been treated differently, both in the criminal justice system, the civil justice system. How are you feeling about what's going on with Ghislaine Maxwell right now?
It is an extremely disturbing extension of efforts to divert attention away from the search for the truth in this case. I have read the entire transcript of the 2 days of interviews of Ghislaine Maxwell conducted on July 24 and 25. I will tell you that it reads, I haven't listened to the tapes, but it reads like a well-structured and choreographed dance. It does not read like the interrogation of a convicted child predator and accused perjurer.
Almost as if Ghislaine knew the questions ahead of time?
I don't know that it was really necessary for her to have known the questions ahead of time, but it wouldn't take anybody with any degree of common sense to have been unable to anticipate what the questions would be. But what is extremely disturbing about this entire process is that the individual conducting these interviews was known to be the criminal defense lawyer of the man who walks around with an unlimited number of get-out-of-jail-free cards in his pocket and has demonstrated a proclivity to hand them out freely.
And who is this person, and who does he get these get-out-of-jail-free cards? I ask, knowing the answer to my question.
Clearly, we're referring to the current president of the United States, who recognizes the fact and has liberally used his authority to grant pardons to individuals accused and convicted of very serious criminal activity. So the president's personal criminal defense lawyer shows up to talk to Ghislaine Maxwell about circumstances that have been reported as potentially incriminating to the president himself. And what do you think she's going to say to any question that is asked of her that remotely could implicate the president in anything that is unfavorable in any respect. It would take an idiot, and Ghislaine Maxwell is no idiot. It would take an idiot to walk into that situation and lay out answers that would be offensive to the man who holds the power to hand a get out of free jail card to her. And if there was any chance that the message might be missed, and I don't see how there could be, we transfer her to a federal country club.
It's just a coincidence. It's just a coincidence, Jack.
Yes, sir. She gets transferred to a federal country club where she can await delivery of the rest of the gift that she is hoping to receive.
Well, Jack, you said that one would have to be an idiot to answer anything against her interest. I guess the converse is true too. They'd have to think we were idiots to believe that she is doing anything other than helping the president. Is that a fair assessment?
Well, Joe, unfortunately, there are many people who do not look beyond the surface. I think there are many who do. And you don't have to dig very deep beyond the surface to appreciate what is going on. But why do you conduct an interview like this and never administer an oath to the witness? It's not there in the transcript. I would assume that if an oath were administered, that we would know about the fact that Ghislaine Maxwell was required to answer questions under oath, particularly an interview subject who was accused of perjury. You would want to be sure that the full panoply of truth-seeking devices were being utilized. You would want to have participating in that interview process people who were well-versed in all of the information that could be used to interrogate such a witness. The chief prosecutor in the case against Ghislaine Maxwell, Maureen Comey, a very experienced and well-respected woman who did an excellent job in the prosecution of the case against Maxwell, she was terminated from the U.S. Attorney's Office for no apparent reason.
Another coincidence, Jack.
Yes, another coincidence indeed, and there are a long string of them. And I happen to be an individual who believes there are no coincidences, but there are those who can dismiss those circumstances as just another coincidence. But wouldn't the person who was prepared to cross-examine Ghislaine Maxwell, if she ever took the stand in the course of her criminal prosecution, who had studied these facts and knew them cold, wouldn't that be a person that you would want to be a participant in the team that was going to conduct this interview? I
That seems right.
Maureen Comey been invited, she'd have been happy to accept that invitation.
Jack, I have just a ton more questions. Can I get you to come back?
I don't know, Joe. Is the compensation going to be the same as it was for this interview? That is your undying friendship?
That will be the compensation, my undying friendship.
Then you got me. You got me. I'm on board.
All right, Jack, thank you for kicking off season 2 of the Academy Speaks. I can't thank you enough, and you've kicked it off in just the right way.
Well,
We are truly thankful to people like you who help to make sure that the rule of law is followed. Thank you so much, Jack.
I appreciate the incredibly fine job that you are doing in conducting these interviews. It's a great service to the Academy, but more significantly, it's a great service to the preservation of the rule of law. Thank you for your efforts.
Thank you. And for those of you who are listening, you can catch us on YouTube or wherever you get your podcasts. I'll talk to you soon, Jack. Take care. Thank you for listening to our second episode with Jack Scarola. It was so insightful. We're having Jack back for a third episode. This is Joe Tucker, President of the International Academy of Trial Lawyers. And thank you for listening to The Rule of Law, the Academy Speaks.